We found in our experience as criminal defense lawyers that there's really three keys to winning an OR motion or convincing a judge to grant an OR release and release our client on his own recognizance. The first is to work with the OR investigator. So in many counties, and Los Angeles being one of them, the judge will send the case out for what's called an OR report before considering the motion. And an OR investigator will be assigned who's supposed to look at the background of the defendant and the circumstances of the alleged crime and recommend whether he should be released OR or not. Now, we can go and talk with the OR investigator during this process and provide helpful information about our client and references and pay stubs and information about his ties to the community. Many times we're able to convince the OR investigator who is going to recommend against release actually to issue a favorable report and recommend that our client do receive an OR release. And that can go a long way in convincing the judge to agree. The second important strategy in getting an OR release is to get the prosecutor on board. Because when we go before the judge at the OR hearing, if the prosecutor objects and goes on the record and makes arguments as to why the person should not be released, then that will tend to dissuade the judge against granting an OR. But what we can do is go and sit down with the prosecutor privately before the hearing and provide good information about our client and why our client deserves to get an OR. If we can get the prosecutor on board to sort of go on the record and say that they have no objection to an OR release, then the judge is much more likely to grant it. Finally, and most importantly, is convincing the judge himself. A lot of times we will bring in letters of character from family and friends and our client's employer. Sometimes we will bring in live witnesses to court to testify about our client's character. I had a client who was an Army veteran from the Iraq War who was charged with vehicular manslaughter. And I actually brought in his commanding officer to the OR hearing to address the judge and explain that our client had served his country in combat and was a good soldier and had impeccable character. And we were able to get an OR release in a situation where otherwise he would have been facing a very, very high bail. Sometimes we'll go into chambers and sort of talk off the record low-key with the judge and prosecutor and plead our case. Other times we'll go on the record and present a full-fledged hearing in open court. But the key is, in each of these cases, to know your judge and to know what arguments and what evidence and what considerations are likely to be persuasive with that particular judge. It's a lot of work doing an OR motion right, but it can be of great benefit to the client. We've had situations where our client was charged with $500,000 bail, and the family was trying to raise the money, and they were looking to pay a bail bondsman $40,000 to $50,000 to get their loved one out of custody. But we were able to get OR release and really save the family a fortune. So it's a situation where an aggressive and savvy attorney can be a very effective advocate.